and all those observing the meeting on Microsoft Teams. Fire alarm procedure. There are no drills expected this evening, so in the event of any alarm sounding, please quickly make your way out of the building. There are 3 exits from this room which members can use to vacate the premises. Please switch mobile phones onto silent or switch them off and take any calls outside of the meeting room. Do not leave any bags unaccompanied or report any unaccompanied bags. Remember to take any bags with you when you leave the meeting or when it is concluded. This meeting may be subject to filming or audio recording by others in accordance with the Council's filming protocol. Anyone who remains in the meeting following this announcement will have deemed to have consented to allow their image to be recorded and broadcast. Thank you. Move on to the agenda. Item 1, apologies for absence. Do we have any apologies, Mark?
Chair, we have apologies from Councillor Metcalfe.
Are there any other apologies from the floor? Oh, thank you. Move on to item 2, declaration of interest. Are there any declarations of interest? Councillor Hammersley?
Thank you, Chair. Yeah. Planning application 2024 0056, land adjacent 125 Princess Street is in my ward. Thank you.
Councillor Jackson?
Planning application reference 2024-0301, the Community Diagnostics Facility for the NHS. As appointed governor for Sherwood Forest Hospitals, I declare an interest in that application.
Thank you. Any further declarations? Councillor Abbs?
Thank you, Chair. Item 5, 240133 CLPD. Sound is in within my ward.
Thank you. That's it for declarations. Thank you. Move on to item 3. Minutes of the meeting held on the 5th of August 2024. Could I have a proposer, please? Councillor Hammersley, seconder. Councillor Stevenson. Can I confirm those minutes as a correct record, or are there any amendments? Councillor Jackson? Confirming, yeah. We're happy with the minutes? Yeah. Can I take a vote then by show of hands? All those in favour who were at the meeting, please show. Thank you. It's unanimous. Move on to item 4, which is planning application reference 2024-0232 con change of use from residential use class C3 to specialist accommodation use class C2, including extension, garden room, internal improvements and associated parking, 110A Little Barn Lane, Mansfield. Could I ask the office to make the report, please?
Thank you, Chair. In terms of updates, there's only one on this application. The front sheet of the agenda incorrectly gives the application reference number as 2024-0232 CON when it should read 2024-0232 COU. So the amendment is the last 3 digits of that reference number as set out in the officer report. In terms of the details of the application, the host dwelling comprises of a modern 5-bedroom bungalow, which is set back from Little Barn Lane at the end of a parking and turning area to the front of the dwelling. Although currently vacant, it's been purchased by Lidercare Group Limited, who are a specialist provider of residential, nursing and dementia care across Mansfield and Ashfield. This application seeks permission to change the use of the existing dwelling to provide specialist supported living accommodation for 6 adults with mild learning difficulties and older adults who may present early signs of dementia. Residents will be assisted by 1 full-time carer who will be on hand at all times to enable the occupiers to lead an independent life as possible. Minor external alterations and a small single-storey extension would be added to the front of the property to provide the 6 bedrooms, and a garden room building, as just shown there, would be erected within the rear garden area for use by the residents and also for staff members who would be at the site. Policy H6 of the local plan relates to the provision of specialist housing and supports proposals on sites within existing or proposed residential areas where they're conveniently located in relation to services and facilities and have been designed and laid out so that they are suitable for people with disabilities or with specific care needs. The host property is located in a predominantly residential part of the town, where there are a range of local retail, community facilities and public transport links within close proximity. It's also providing accommodation over a single level, meaning that it's easily accessible and there's an access ramp into the rear garden, enabling any disabled residents to be able to access the substantial rear garden. The layout of the bedrooms and internal floor area would also comply with the Care Quality Commission's minimum internal space standards and be fully wheelchair accessible. As such, the proposal, in the officer's opinion, would accord with policy H6 of the local plan in that respect. The property is also located at the end of a long private driveway, which is secured by electric entrance gates. So you can see the long driveway there. That's a photograph taken from within the site, looking out towards the main road. The electric gates are positioned in the distance there on that photograph. I think is there another photograph, Dan, which is we'll show that. There we go. So that's the electric gates. As you view from Little Barn Lane. So that's the private access driveway off the road. So there's quite a substantial distance between the highway itself and those electric gates, where any vehicles accessing the site can actually wait without obstructing the highway. And as the occupiers wouldn't own their own vehicles, the only actual vehicles that would be accessing the site would be staff members and visitors to the site. And as you can see, the electric gates would enable access to be controlled. So the staff members within the facility will be able to open those gates and allow visitors and staff members to actually access the property. So it's considered that the access arrangements wouldn't have an adverse effect on highway safety, and the test in the National Planning Policy Framework with regards to the impact on highway safety is if the development would have a significant severe impact on highway safety. So that's the test it would need to fail if it was to be refused on highway grounds. And also the parking area within the site, as you can see in these photographs here, can accommodate up to 4 vehicles at any one time. So we're talking of, I think it's a maximum of 2 staff members who may have vehicles and any visitors. So that's quite a substantial area, which would provide sufficient parking space within the confines of the site to meet the parking demands of the facility. In terms of the impact on residential amenity, it is accepted that the site's within an established residential area, so there are residential properties within the surrounding environment. However, given the size of the plot and the controls that will be placed on the facility, where members of staff would be able to ensure there's no adverse impact from any residents who may reside at the property on residential amenity in terms of noise or disturbance. Also, there would only be 6 residents on site, which then therefore the impact would be similar to that of a large family dwelling the existing situation is a 5-bedroom bungalow, so potentially you could have a large family unit with a similar number of occupiers within that, with it being occupied as a residential dwelling. Therefore, it's recommended that planning permission is granted subject to a condition restricting the total number of residents to 6 and 1 staff member being present at all times. So there may be two staff members on shift overlaps who may be on site, but that would only be for a very brief period of time.
Thank you for your report. I've got several speakers on this application, so I can invite you up to the podium. Could I ask Rebecca Wood to come forward, please? If you turn your microphone on, then you've got 4 minutes to speak when you're ready.
Lidercare have not made it clear for the residents that will be living at 110A. They have stated that specialist accommodation will be provided for adults with mild learning difficulties and will include older adults which may present early signs of dementia. Why was Lidercare's company house statement amended in December 23 to include within their nature of business residential care activities for learning difficulties, mental health and substance abuse? The alarming part of that statement to us is substance abuse. What guarantee can Lidercare give to say that the proposed change for specialist accommodation will not include substance abuse and will be as stated in their proposal? Or in fact, will the residents with early set dementia be caused directly by chronic intense drug use? Will the one member of staff working be expected to provide care, supervision with possible challenging behaviours, provide activities, clean, cook, garden, manage visitors, administrate medication? Who will provide supervision during the staff's entitled break? Will this mean outside agencies are used to cover some of these duties, increasing traffic flow on the shared access drive to 110A and further on-street parking issues? Staff will assist occupiers to lead an independent life and independent living. So why won't they be able to leave the property unsupervised or drive? The details in the agenda are incorrect, and where it refers to the long private driveway in which visitors and emergency delivery vehicles can use as a waiting area, the long driveway they are referring to is actually an access way to be used by 110 and 110A, and the electric gates does not signal a part of their drive. 110A's driveway begins at the boundaries of the bottom of 110's garden. Access way cannot be obstructed by either 110 or 110A. Prior permission was obtained to construct the electric gate from 110 and the previous owners of 110A to aid with safety of the disabled lady who lived there. Frequent ambulances would attend, none of which would drive down and would reverse due to being unable to turn. There was only 2 cars in the household at that time. Since the property was purchased, I have observed many visitors not using the drive. This demonstrates to me how unaccessible 110A is, and I will put to you that even the most experienced driver parking 4 cars and having a turning circle is a struggle, if not impossible. The agenda states that residents will not be able to drive. How do Lidercare know a person with a mild learning disability will not be permitted to drive? Have any of the planning committee observed the area in which Lider are detailing as 4 car parking spaces and a turning space? On Lidercare's website, they state, "We welcome visitors to the home any day of the week as we feel it's important for the residents to have as much contact as possible with their family and friends." What makes 110A any different to residents in their care home? Where is their human right as a person living an independent life? Who makes the decision who can visit at what time? Who will ensure that the allocated car parking spaces are being used correctly? Nottinghamshire Police have not raised any objections, but are Lidercare being transparent of the type of clientele they will be housing? Can this company guarantee what they have put in their proposal will happen, and if the planning is accepted, continue to stick to what they have proposed?
Thank you. Do members have any questions of the speaker? Councillor Answer.
Thank you, Chairman. Rebecca, can you tell me, please, this drive, you say it's a shared drive?
Yeah.
And looking at that picture there, where is the access to the other property?
So the other property, so all down the right hand side of where the fence is, that is the other property I'm referring to, which is 110. So their driveway starts where the gravel finishes, and it goes onto the block paving.
So they have to go down that drive?
Yeah.
Thank you.
Any other questions, Rebecca? Councillor Abbott.
I can see shakings of heads, but I have got my deed if anyone wants to look at it.
Rebecca, thank you for your report. Go back to the photo, please. You're saying that where the drive ends, where the actual, where the blocks are, block paving, or entrance is there to get into your property, or whose property it is, or is it beyond the gates that they've got as electric?
We have got a separate drive, but we have got access to that lane. We have got a key to that, the electric gate, that when
Right.
they got put up, that was the thing we needed a key for it in case we wanted access down there.
Okay, thank you. Appreciate it.
Any other question? Councillor Tempest Mitchell.
Hi, Rebecca, thank you. So I take it you live at 110?
Yeah.
If and when, and I don't know if it's already sold, but presumably it is, can the person that owns 110A block your access to that driveway?
If they parked on that access way, yeah.
Correct. No, I meant legally. Can they legally say you don't have access to this? I get that
No.
you've had access from the people that lived there before.
So when I bought my house, it's highlighted, the solicitor has highlighted it to say that access way is for both of our access way, and their drive begins at the end of my boundary.
Just one more, Chair. Yeah. So is your main objection to the proposal the driveway issue, or the house, or the residence?
So,
What way?
well, because I just don't think it's appropriate for the area. Lidocare has not made it clear what the housing's for. As I've just said, it said substance abuse. So if that's going to be substance abuse, would you want that at the bottom of your garden when you've got 2 young children? About it.
No further questions? Thank you, Rebecca. Right, Josephine Cairns. Same. You want to turn your speaker on and then you've got 4 minutes.
It is unclear of the disabilities and mental issues of the people who will be living at 11A Little Barn Lane. Lidocare did state that the residents would have mild disabilities or mental issues. Why are they not being offered homes in independent living accommodation with the appropriate help and supervision to lead an independent life, or perhaps even being accommodated in one of Lidoc's purpose-built care settings? If the disabilities or mental issues are of a more severe nature, one person supervising and caring for 6 residents is certainly not adequate to provide the care, guidance and protection to meet the needs of those people. Lidocare did state that the area on Little Barn Lane was close to the local bus services, library and various social venues in Mansfield Town Centre. This would enhance the lives of the residents. I have noted on the agenda, page 12, that the residents will not be able to leave on their own accord. Could it be explained whether the residents will be allowed to attend these venues unsupervised or will not be allowed to attend these venues? There are concerns for the number of vehicles that will access the driveway, care workers, social workers, delivery vehicles and maintenance staff. Also, taxis will probably be needed to transport people with physical disabilities. Lidercare has commented that the building has full wheelchair access. Will Lidercare be providing a minibus to cater for the residents' social needs? The bottom of 11A is located close to an area known as the racecourse. That area has on many occasions been subject to unsociable behaviour involving drugs and substance abuse. Also, several fires have been started deliberately. The last one on 19th of July of this year, resulting in the emergency services being called to extinguish the fire. I therefore feel the accommodation is not suitable for people of a vulnerable nature to be housed there. It is quite apparent that due to the increasing numbers of people with mental issues, that there is a severe shortage of appropriate accommodation. The local authority has a duty of care to ensure that their needs are being met in the correct environment with the highest level of care. Over the past 20 years, the council has closed care homes and daycare centres. The land has then been sold off to property developers. This issue will only get worse and needs urgent consideration to address this problem. Companies purchasing properties in residential areas is not the long-term solution for this shortage of accommodation. Apart from the companies purchasing these buildings, I doubt that anyone present in this room can reasonably disagree with the comments I have just made. And would the panel please define the implications of comments on page 15, number 5 of the agenda, please?
Members have any questions of the speaker? Councillor Abbs.
Thank you for your report. Appreciate it. The thing we said about fire, that should and would have been looked at before this plan occupation taking place. So effectively, they would have been okay on that side of things, or it wouldn't have got this far in any case. What makes you think it's going to be desirables going down here? Or
I've lived in my bungalow, more or less just opposite, for 53 years. And over the years, I've witnessed lots of unsociable behaviour down off the racecourse. And I think vulnerable people that's going to be housed there, there's going to be on the garden that backs onto the racecourse. I think they're going to be very vulnerable from local undesirables, especially that there's going to be one person supervising that's doing all the other duties, care plans, washing, cleaning, cooking. I just do not think these people are going to be have the proper supervision that they're entitled to.
okay, thank you. Thank you, Chairman.
Councillor Jackson.
Thank you, Chair. Thank you for your representation. Can I just clarify my understanding that what you're saying is that you're concerned about the impact on vulnerable residents in that home from other people, not necessarily from themselves? Have I made sense there?
I'm concerned for the well-being anyway.
Yeah,
One person for 6 vulnerable people
yeah,
is not adequate. I worked in a care setting for 30 years. Okay, it might be acceptable for one person to supervise,
mhm.
but that one person it's impossible that they can do the cooking, cleaning, care plans, fire drills, be responsible for their safety. It's impossible one person can do that.
So I'll pick that question up perhaps after, but so what you're saying to me is you're concerned for the well-being of any potential residents, but you're also concerned about outside influences. So people coming from Racecourse Park, for example.
Yes, and
Okay.
also, will these 6 vulnerable people that I'm not sure whether they're going to be allowed to go out unsupervised
Okay.
or not, will they be allowed to bring friends back?
Well, I don't think we can answer those questions,
what I'm
but yeah,
saying,
I take your point.
But
Yeah.
these questions should have been answered prior to this meeting.
Okay, Thank you very much.
Yeah.
Thank you.
Okay.
Thank you, Chair.
Any further questions of the speaker? No, no one's indicated. Thank you.
Okay, thank you.
Can I invite Bob Willard? Same procedure, Bob. Speakers left that light on, so you're ready to go. 4 minutes when you're ready.
Yes, thank you, Chair and Committee, for the opportunity to speak about this application. I'm Bob Willard. I'm the agent speaking on behalf of the application, which obviously involves the reuse of an existing house as a supported home, as has been mentioned. And just to be clear, and I'm sure your officers will further guide you on this, but obviously it's the use that's being considered here, not the detail of the occupancy. It is just simply a different type of residential use, but it is a residential use. Just to clarify as well, for the committee's benefit, as is set out in the application, the occupancy is for adults with mild learning disabilities and older people with early signs of dementia. It's absolutely not intended to be a home for people who have problems to do with substance abuse. That's not what this is for. But obviously, this is simply a residential use. And the Litter-Care Group has a long-standing reputation for providing quality care in Mansfield and Ashfield, and there's a critical need for supported living in this area. This will provide not only a safe and structured environment, but also empower residents to achieve greater independence while having access to professional support when they need it. This isn't a high level of care. This isn't cooking and cleaning and personal care. These are people who are able to look after themselves and live independently with that additional little bit of help and a little bit of support. That's why those staffing levels are as they are. By offering this type of accommodation, we're ensuring our community is an inclusive one and responsive to the needs of all its residents. The residents are going to be local people. They're people who are already living in the community. They just need that additional bit of support. The location's well suited. It's in a residential area, easy access to public transport and community services. If those residents are going out of the building, they will be supported to be able to do that, and they will be supervised in doing that. That's not to say that they're going to be shipped out on minibuses and having large amounts of transportation, large amounts of coming and going. That gives them opportunities to engage with local activities and services to enhance their quality of life. It has been thoughtfully thought through to reflect a commitment to both the well-being of future residents and the preservation of the local character. This application is going to contribute to addressing housing needs of Mansfield, and it aligns with both national and local policies. It's a project that not only addresses a specific housing need, but also strengthens the social fabric of the community by promoting that inclusivity and diversity. We acknowledge local concerns about parking and access, but this is a residential home with an element of additional care. It's not a commercial development. Comings and goings will be no different to a normal residence. Residents themselves absolutely will not have cars themselves. And as is confirmed in your office's report, the parking provision accords with the county's standards with appropriate turning available.
30 seconds.
Moreover, this being a managed property, local people have a professional and accountable organisation that they can go to if they have concerns about the operation itself. In conclusion, it's a thoughtful, sustainable and necessary development that addresses an important gap in our local housing market. So we respectfully encourage the committee to endorse your officer's recommendation, and it's a step towards building a stronger, more inclusive Mansfield, where every resident has the opportunity to live in a supportive environment that meets their needs. Thank you.
Thank you. Do members have any questions of the speaker? Councillor Jackson.
Thank you, Chair. Thank you for that. I just want to go back to the concerns raised by residents about one member of staff on duty. And I accept what you're saying about the residents not needing a level of personal care. But if residents are going out, how is that facilitated when you've only got one member of staff on duty? And as one resident said, how will that member of staff take their break? So what would those arrangements look like?
Yeah, it's up to 2 members of staff
Okay.
available. But obviously, it could be that one member of staff remains in the home, takes 1 or 2 members or residents out, or it could be that Lidercare, as the management organisation, is able to provide somebody else to come and take a resident out, or they may be taken out by their relatives.
Okay, thank you. Thank you.
Any further questions? Councillor Moxham.
Yeah, thank you. Got a query about in the one of the planning recommendations of the conditions is to is that there's only accommodate a maximum of 6 residents, and yet it's a 5-bedroom house. How does that work? How do you get 6 residents in 5 bedrooms?
Yeah, so the extension element of the application provides that additional bedroom. So the extension provides 6 bedrooms in total.
Councillor Bell.
I want to speak, obviously. Thank you, Chair. I've got concerns as the 2 objects. The medication, you say there's only going to be 1 person there, then on the other hand, you've doubled it, saying that there will be another person there to escort them if they need to be. I have got grave concerns of the medication. 1 person, me, cannot look after 6 people, and they've got learning difficulties, still medication required, and that is of grave concern to me. Totally agree with objectives for that. And to me, that's a no-no. Then you've doubled it, and it suits somebody will come and escort them. So we've gone from 1 to 2, causing parking problems already. Thank you, Chair. Sorry, Chair. Yeah, it's just we've gone from 1 to 2. We've only got 1 person in charge of the medication. I find that a bit iffy. Very.
You're not to speak when you're not allowed to speak, members of the public. Thank you.
These are all on level 2. Upwards to 1.
Sir Tempest Mitchell.
Thank you. Few questions, but one, what consultation have you had with the local residents up to this point? Secondly, Rebecca told us that on your website or in Companies House website, there's mention of residents who may have substance abuse issues. Does your company anywhere have people who are in residential care because of their substance abuse? The company. What was the average age that you would think of the residents? Okay, thank you.
Councillor Moxon.
Thank you. So you've told us, one of the councillors, that these are people that have got quite mild symptoms so far. So does that potentially mean that some of them will still be driving? Because I know people that they've got mild dementia or early stages of Alzheimer's and are still driving. So does that mean that potentially some of the residents will still be driving and therefore will have a car and require the use of parking it there? And you've not got your microphone on, by the way, so it won't get picked up by the recording.
Apologies. None of the residents will have cars,
Categorically.
categorically.
You asking another question because your light's still on.
Sorry. Yes, I did. Sorry, thank you. The electric gates at the front. So we've had some a little bit of conjecture about that, and I'll ask a question of the planners shortly. But I just wanted to know who would have access to the electric gates, because I've got concerns that if the staff and or visitors don't have very easy access to being able to get into the electric gates, people inherently go for the easiest option and would potentially just park on the road. So what access do staff and or visitors would they have to the electric gates?
Yeah, so the staff would have control over the electric gates. So any visitors arriving at the site, they would be able to provide them with access.
Any further question? Councillor Answer.
Thank you, Chairman. With 6 residents in there and one person basically supervising, and you say they can only leave with an escort or somebody supporting them, what's to stop them just getting up and going out?
Sorry,
What is there to stop them if they decide they want to go out themselves? If they, as you say, capable of doing things themselves, if they decide they want to go out, go for a walk, or go into town themselves, how can you stop them?
As I understand it, obviously they would be encouraged to be supervised on when they're leaving the premises. It's not a secure institution. It's not a prison. You know, these are members of the community. They're our brothers and sisters, our parents, our children. They're people who are people in society. So they are obviously, they have a right to come and go. But it being a managed facility, there being a member of staff there, unlike if they were living in a home on their own, there is obviously that control and that care and that support to assist them and help them to live those independent lives, so that, you know, I suppose we're all aware of the risks with dementia of people wandering, and that's a known issue. If they're living in their own homes on their own, that's potentially a risk. Whereas obviously with this being a managed and supported facility, there'll be a member of staff there to assist and help them and ensure that kind of thing doesn't happen.
The question, councillor Answer.
Yeah, I mean, I guess if that were the case, obviously the fact that there are staff there, if they needed additional support or they needed to contact the emergency authorities to assist, there's somebody there to notice that that has happened, and to ensure that that is managed and dealt with. That's the beauty and advantage of this being a managed facility, is that there is that care and there is that staff there to ensure that if there are incidents such as you suggested, that can be readily and easily dealt with.
Councillor Tempest Mitchell.
Chair, sorry for coming back. Can we just clarify one thing? Through the day, how many staff are going to be there?
One or possibly two, depending on the needs at the time. Up to two. One or two, depending on.
Members of the public refrain from speaking. You're here to observe. You cannot speak. If you carry on, I'll have to have you thrown out. Missed your questions. Councillor Abbs.
Thank you. First and foremost, thanks for your report. And I know you're not part of the organisation that's in, but to me, there's a lot of unanswered questions. Is getting out on the road with just one person or even two walking around. There's no mention and how they say if people can actually get into them from the park area, the race course. Are they putting in automatic locks where you have to have a pass to get in and out? Do you know anything of that sort of thing that's happening? So when there's a fire, obviously it automatically opens, but when it's not, it's locked, so they know it's safe. Do you know anything of that sort happening?
I don't specifically know in terms
Okay.
of passes and secure access, and obviously this is a home like any other home on that street, that there are residents living there, and there will be vulnerable people in other homes on that street. But the difference in this case is that this is a managed facility, so there will be somebody there to obviously support, care, and ensure that any issues arising can be dealt with speedily and satisfactorily. And as I said, in my own notes, the fact that there is a professional management organisation running this home means that if there are residents, if there are specific concerns about the operation, residents have somewhere specifically to go to and a contact that they can get in touch with to raise those concerns and ensure that they're satisfactorily dealt with.
Thank you for your answer. It would have been wise the company to actually have open with them to tell exactly what's going on. Same time. Obviously not. Anyway, thank you for the answer. Appreciated.
See any further questions being so thank you. The officers will clarify some of the points that you're making. You can't ask questions. I'm sorry, you can't ask questions. You had time to speak and that was it. Yeah. You're not listening. They'll be covered by the officers later. Right, final speaker, Councillor Garner. You've got 6 minutes. I think you know the procedure.
Thank you. My name's Councillor Garner, member of the Racecourse area. Right, we've all heard the debate. We've had one worker, and we might have had two. We've had a gate, or could be open, or could be shut. I don't know. I'm getting confused myself. I don't think this stacks up with one worker. One worker, 6 people with different needs. From a full length of the spectrum, from mild to very vulnerable, from probably 20 to 80 dementia, broad area of adults there in an home. Is that right? One person to look after them. And it's just, well, you know, I can't emphasize what these people have said. And we've got the road. Last week, when I got the papers last week, I got them last week on them before I went away for a few days. And I read them, and it says you can park 4 cars. Well, probably a computer can park 4 cars. But people actually driving and parking 4 cars and getting them, having the ability to turn them around and pointing them the right way to come out, I don't think they can. So I went to a gentleman who lives on Lamley Avenue, just round the corner, and he was a lorry driver. And I says, can you go down there and have a look at this and see if you can park 4 cars down there? And he says he couldn't, and he's a lorry driver. I'm not just saying it because of what he said, but that's what he said. Have we been out as any officer, any committee, been out to have a look at this? Viewed the drive, viewed the gates, viewed the shared drive, viewed the parking facilities? I don't think you have. And also, regarding the mystery 6th guest, they're going to have an extension on the front. So if the extension's on the front, that's less parking. Has anybody thought about that? Because to me, if you build something on the front where the parking is, it's going to be less. You can't magic land. So anyway, that's all I can say. He's done a fantastic job. These are absolutely correct with what they're saying. And I urge you to reject this application. Thank you.
You, Councillor Garner. Right. Do members have any questions of the officers? Can I bring Claire in to do a point of clarification first?
Thank you, Chairman. Just to clarify, this application has been considered on the basis of 1 carer on site at any one time, and that is conditioned. So I know Mr. Woolard talked about 2 carers on site, but you'll see in the list of conditions that, and you'll see, if you read the supporting statement that's been put in, it says 1 carer on site at any one time. So we've allowed a little bit of flexibility in the condition to allow a changeover of staff, but it is not officers' understanding, and the recommendation has been based on 1 carer on site at any one time. So yeah, in terms of highways, you can see from the block plan there, there's 4 spaces on site, and we've had no highway objection. I think the lady that spoke first, in terms of the road, to me that seemed a private matter between the 2 individuals, because I can't see how I can understand where the surface changes, and that probably is an ownership issue, and that's, I mean, obviously I don't know the deeds, but I think she said that it goes to where the change of the surface was her ownership, but I can't see an access going in round the back to her property. So I think that is a private matter between the 2 property or 2 owners there.
Do we have any questions of the officers then on the report? Councillor Abbs?
Thank you. Thank you for that. Appreciated. You know where you got your parking spots on the actual map there? Is that including the extension as well as?
Yes, it is. And
Sorry.
yeah, it is an extension, as you can see on the top top of the picture there.
Yeah.
That would actually go within an area which is currently shrubs and gardens, so the actual hard standing area wouldn't be reduced. And as Claire says, the Highway Authority are happy as the experts in terms of parking and turning facilities that 4 vehicles can actually park on that site. And I've been to the site myself, and it's clear, as you can see with the arrangements on that plan there, that you can fit 4 vehicles on and they can turn. And obviously you're not going to get 4 vehicles on there all the time. You will be getting visitors intermittently coming to the facility and moving away, and staff, there will only be a short changeover of staff. So there will be some of those spaces will be vacant to enable vehicles to turn around on that site and exit in a forward gear. And also you have got the driveway in front of the gates as well within the site.
Sorry, I apologise. I didn't mean to interrupt. I thought the driveway was shared. Can't just park this, surely.
Would you mind putting the block plan on, Dan?
Just re-explain that. Then.
Yeah, so essentially, as you see there, the driveway we're talking about is covered by the red line.
Yeah.
So number 110 has got its main vehicle access and parking area at the front of that property.
Yeah, that's right.
So their vehicles predominantly use the existing driveway access on their property. So I understand that they've just got a right of access over that driveway. So predominantly it is a main vehicle access for the host property, which is subject to this application. So that's the arrangement. So you've got that long driveway before you get to the access gates, and the access gates are positioned some way up that private access drive. So you could theoretically get quite a few vehicles on that driveway without causing any nuisance to the main highway on Little Barn Lane. We've got the photographs of where the electric gates are as well. So you can see where they are, and if you scroll through the photographs further back straight to the main road there, so they're there. So you can see that if you go there, that next one, Dan. So that's taken from where the electric gates are.
Yeah.
So you can see there's quite a significant length of driveway before you get to the highway.
Done that. I thought was a shared driveway all the way down to the block paving.
But they've only got right of access, as I understand it. So it's no, they don't drive their vehicles down there. They may have a legal right to do that under their deeds. I haven't seen that, but it's not, there's no vehicular access to the rear of their property, as you can see there from the photograph. It's all,
I could tell that.
it's close bordered fences that block it off. So, you know, yes, they may have a right of access, but that's the physical situation on the ground. Yeah.
Yeah, no worries. Thank you.
Any further questions to the officers? Councillor Hammersley.
Tom, just following on from councillor Abb's question, the driveway down to where the block paving starts, and the land where the electric gates are situated, is that owned by 110A?
And that the access until you get to the electric gates is under the applicant's control, but he's got it's a shared right of way. I haven't seen the applicant's deeds, so sorry, the neighbour's deeds, but that's how I understand it, is that it is under the ownership of the applicant until you get to the electric gates. I
think just
Just want to clarify.
I think just to come in there, that in terms of land ownership, planning wouldn't necessarily see that as a material consideration anyway. When we're talking about parking, members just need to be aware that there are 4 spaces shown on that site, and then assess that against the requirement of the Nottinghamshire Highway Design Guide, which requires 4 spaces. So really, regardless of whether people are parking on a road or may not be, it's a little bit of speculation. What we have to look at is what's in front of us in terms of the plan, and the plan is clearly showing 4 spaces.
Councillor Tempest Mitchell.
Tom, safety of residents in the home, i.e. 6 residents with 1 member of staff, reason for refusing.
I think we have to consider the way the planning policy is worded is it's existing and proposed residents. So we do need to take into account the amenity of neighbours and the proposed occupiers of the new facility. However, in our opinion as officers, the 1 staff member would provide sufficient care for those 6 residents due to the nature of their mild learning difficulties and early onset dementia. So as officers, we feel that that level of provision would be acceptable.
In terms of it's a fine line, I think, between when you're looking at perception and then planning needs to look at evidence. And this might help, it might not help, but I had an application for a children's home it was in a previous authority I worked at. And I was looking for the appeal decision when everybody was talking, and this was, it was refused on the grounds that the impact on the area, because it was a high crime area, on the impact of the children. And whether it would lead the children down. And I think that's sort of very similar to what you're saying in terms of the vulnerability of the residents, and are these residents vulnerable? But the inspector in his report, he said, I recognise that the council may have perception that children who may occupy the appeal property will be exposed to crime. However, such perception needs to be soundly based on evidence and relevant to the provisions of the development plan, if I am attached any significant weight in the planning balance. So I think that's quite important, that it has to be evidenced, and as officers we can't see any evidence that people living in this area they will be vulnerable. They are vulnerable people. However, it comes down to the management arrangements of the home. So it's very difficult to prove, and evidence is what it would be my advice.
So Stevenson.
Chair. There's been some mention of potential residents with substance abuse issues. You'll forgive me if I can't see it in the conditions that it is there. I have had a look. What sort of guarantees can we give that there wouldn't be any residents dealing with substance abuse?
think the applicant had, well, the agent had given some comments on that in their representations, in that the organisation may accommodate elsewhere people who may have issues with substance abuse. However, the intention is for this application is that it's a different nature of accommodation. So those people may be housed in more secure environments, whereas the intended occupiers of this property are going to be those with mild learning difficulties and early onset dementia. So the company has a different level of provision for those people. That's how I understand it anyway.
So without a condition in the planning, should the company decide to change direction in a new way, or start accommodating for residents going through different vulnerabilities such as substance abuse, nothing to say that they couldn't put someone on this property through those things without enforcement actions. Would that be correct?
I don't think we'd be able to specify in the conditions the specific, it would be unreasonable probably to do that. Claire?
I think I agree, and I think here planning doesn't tend to look at people who live in the properties per se. It's about the use of the land. So this application is for the change of use of a C3 dwelling house to a C2 use, which is a residential institution, and that can cover multitude of people living there. So I think we wouldn't be getting down to the actual exact details of conditioning who can live in a property or not. You could have, for example, a C3 use and people could move in who have got, the similar issues. So I wouldn't recommend that.
Appreciate clarity from both of you. Thank you.
Any further questions? Councillor Moxon.
Yeah, thank you. Can you just clarify the property as it is at the moment? How many bedrooms is it?
Currently a 5-bedroom property, so the extension and internal alterations to the building would provide a 6-bedroom facility with shared communal space for the residents to use.
Is that subject to a separate planning application then?
So that's subject to this application as well.
That's part of this?
Yes, it is, yeah.
So it's not just a change of use?
No, it's change of use and extensions.
Any other questions of the officers? No. Thank you. Can I seek a proposer for the recommendations, please? Councillor Stevenson, seconder. Councillors, we're in debate mode. Anyone want to say anything on the application? Councillor Tempest Mitchell.
Thanks, Chair. For me, this has probably been the most, not difficult, but the most complex application that I've had to deal with in the year on the planning committee, because there's all sorts of different sides to it, whether it be the vulnerability of the residents, and we all know that we need homes for vulnerable people, whether they be kids, older people, or people with learning difficulties, dementia, etc. And it seems that this house, as it is now, and with the extension, is probably an ideal place because it's just far enough out of town, but near enough to town for people to get out and about and get some exercise and see the real world. But at the same time, there's a lack of clarity in the application in that we're told there's one member of staff. Now, don't know that I'm correct in saying this, but sometimes when somebody tells me that there's going to be one number and then actually it's double, puts a massive doubt in my mind. We've had that today, that it should be one, but actually it's probably going to be two. And it seems practical to me that it would be two because you've got 6 vulnerable people. One's probably not enough. I suspect, and I may be wrong, that it's because the parking is tight in that small courtyard. Might be wrong. And at the same time, we've got Rebecca's easement of using the driveway and her children, and she's clearly worried because of the mention somewhere of substance abuse. And I can't get my head around that, whether that could ever be a possibility. And as Councillor Stevenson asked, can we guarantee that there won't be anybody ever with substance abuse? No, we can't. And even if we could, we probably couldn't stop it. I don't know if the CQC would be involved in somewhere like this. Maybe they're the only people that could. But a blended family could get together and have 3 kids each from age 9 to 19 or older. They could have 5 or 6 cars between them. It'd be like butterflies, people in and out, reversing down that driveway. And that'd be no different to visitors coming to see these vulnerable people. So I find it quite difficult, this one, because there's so much to weigh up. And I still haven't made my mind at which way I'm going, to be honest. This stage, it's a difficult one. Lord knows that these people, whoever they are, and they could be somebody's mother, dad, granddad, grandma, could be us, getting older now. And we need somewhere safe to live. And I have been up there actually, and it seems like a nice place for somebody to live. So we take it on honesty and trust that there won't ever be anybody with substance abuse that could cause danger to Rebecca's children or other residents in the area. Can't guarantee that. So I have doubts, and I still haven't made my mind up. Thank you.
Councillor Jackson.
Thank you, Chair. I share some of those concerns that my colleague has raised. What I would like to say is, on the pure basis of change of use and the suitability of the property, I would support that. However, I would like my concerns about lack of assurance noting. I am not assured the number of staff with the comings and goings. I think that's my concern, although accepting that that's not a material consideration. So I too am finding this quite a difficult decision. I just want to make that point. Thank you.
Yeah, I think members' concerns on this, but if you read the report covered on page 11, the living accommodations, and then it's a condition stated that only 6 residents and 1 member of staff, excluding the changeover period. We are sort of looking at maybe there'd be more staff and this and the other. But if that was the case, it would have to come back. It's conditioned for 6 residents and 1 member of staff at any one time with the changeover. So if they wanted to have more support staff, they would have to come back and as a material condition. But it's actually in the conditions. I can take your concerns. It is covered in the report. Councillor Moxon.
Yeah, similar to what my previous colleagues have said, this is is the most complex one that we've dealt with in the last couple of years. I have just got a lot of doubts in my head about it when you look at the report on its own and you see where it's situated. And I do know the area, and Councillor Garner, I have been to have a look at it, and I know Little Barn Lane very well because my grandma lived around the corner from where this is. But I'm just I think from listening to the residents that have come and from also from the agent speaking, just a lot of doubts have crept in to my mind. The whole premise of it has sort of started to unravel slightly. I take the point about the one member of staff, and that's in there. I guess my point is, I think having six residents in there is too many anyway. For me, there's a lot of question marks about the access rights and about whose gates they are and who will have access to them. I'm not convinced that they will actually even use the alleged 4 parking spaces in front of the house, and I think they'll end up parking on the road, regardless of what the Highways Authority says. That it's acceptable, because people are creatures of habit and ultimately go for the easiest option, like I said earlier. So I don't think I could support this application. There is just far too many doubts in my mind, and I can't support it.
Sorry, Abs. Sorry, Councillor Bell.
Chair. No, I'll leave it. There are too many unknowns. Change when I wanted to most immediately. That initial 6 is not. Totally agree with. There's too many unknowns. Frightening, really is to me. Chair.
Councillor Stevenson.
Thank you, Chair. As someone who's had a grandmother going through dementia care quite recently, I can attest to benefit of a family member being kept in a situation like this. My grandmother lived with my parents for quite a long stretch into her dementia care, in fact, until it was almost impossible to not get additional care. And the benefit to her quality of life was significant. Places like this are needed. It's been mentioned. This is for very early stages of this type of care. It's clearly an emotional subject, but I know people have mentioned that there's many variables here. I don't think there is. I think most of these questions have been answered. There's a condition in the report that there will be one member of staff. There's a lot of speculation on this might happen or this might happen. We as a committee can't speculate. This is what might happen. We can only base it upon the reports in front of us. We're not highways experts. Highways have said that it's correct. It can only go on the basis of what we've been told from people who are in these positions to make these decisions. So I will be supporting this. I think it is clearly something that will benefit people who will live there, and I hope that others will support it as well.
Thank you, Councillor Stevenson. Any other comments? Just like to bring Claire in again to clarify a couple of points that have been made there.
Don't want to think I'm repeating myself too much, but when making a decision, I think you need to stick to the planning considerations and exactly what Councillor Stevenson just said, the evidence that's before you and the proposal that's before you. So we have a change of use with an extension from a C3 residential house to a C2, which is a residential institution. There's a fine line how much planning can control the management of such institution, because it's controlled by other. I'm no expert in residential care, but there will be, I would have thought, controls in there in terms of staff ratios and things like that. But that you need to stick to the actual planning considerations. We have no objections from Highways in this application. The car park in accords with the Nottinghamshire design guide. I do believe that the private road access it is private matter between the two properties. And like I've said about vulnerable people in this environment, it comes down to the management of the actual institution itself. We can't guarantee who can go in there, and you can't do that for any dwelling, and you can't really do it for any residential institution. So that's the facts before members tonight. So, and that's what a decision should be made on. Hope that helps a little bit.
Thank you, Claire. With that, we've had a proposer and a seconder. So I'd like to take this motion to the vote. All those in favour of granting permission, please show. All those against? Thank you. Any abstentions? Thank you for that. That was motion carried, 6 votes to 2. No abstentions. 7. Got to count myself. So application 2024-0232 COU. Change of use from residential use class C3 to specialist accommodation use class C2, including the extension, garden room, internal improvements and associated parking, has been passed. Subject to conditions. Thank you, committee. I'll move on to item 5 on the agenda, which is planning application reference 2024-0133 CLPD, application for a lawful development certificate under the Town and Country Planning England Order 2015, home for 2 children with support worker, no more than 6 residents, where care will be provided.
Thank you, Chair. If I could excuse myself because of the
Yeah. Let you in. Councillor Abs has left the room and to make a report. Thank you.
Thank you, Chair. So this, as has been stated, so this application is for a lawful development certificate to effectively change the use from a residential dwelling to a residential institution. So there would be it's for 2 children on site between the ages of 7 and 17 with a support worker. So the support workers could, so there'll be a minimum of 2 staff on site at any one time, depending on the needs of the children. That would potentially go up to 4 carers on site at any one time. That would be dependent upon the children. So so the application, unlike the previous proposal, it's for a lawful development certificate. So it's not a planning application in the same sense that the first item on the agenda was. So the normal material planning considerations don't apply in the same sense. So the case before the committee is, so you've got an application or a site in C3 use at the moment going to what would be a C2. So the reason it's a lawful development certificate rather than the planning application is effectively the question that the legislation asks is, does the the proposed operation, would it constitute development for the purposes of the Town and Country Planning Act, which in this case is, would the change of use be a material change of use, and then therefore would planning permission be required? Now, my report kind of it sort of goes into the assessment of why, as officers, we feel that the change of use wouldn't be material. So things such as the number of people on site at any one time, number of vehicles, typical sort of impacts in terms of noise that would be associated with the use of the land at any one time. And essentially it's felt that the proposal that is before the committee tonight would not require planning permission in the same way that the previous proposal would do. So you wouldn't have necessarily any more people on site than that would be expected of a typical residential dwelling. There would be a minimum of 2 staff that would be on site. And I think another key thing is that children are not capable of forming their own household. So from the perspective of, normally in many cases C3 to C2 would require planning permission, but as part of case law, children can't form their own household. So it's an assessment of the materiality of the proposal. So any visits from social workers will be between normal working hours. There's off-street parking provision for no more than 3 cars, and it would be anticipated that the maximum number of cars on site at any one time would be 3. As I said, the nature of the use is not greater than what would be expected of a typical residential dwelling. So for those reasons, it's considered that the subject to the schedules outlined at the end of the report, which would be 2 children on site and no more than 4 staff on site at any one time, that the proposed operation would be lawful and planning permission would not be required. Therefore, it's recommended that the lawful development certificate is granted subject on that basis. Thank you.
Thank you for your report. I believe we've got 2 speakers on this application. So I'd like to invite Richard Williamson. Like to come down to the podium. You turn the speaker on the machine, and you've got 4 minutes.
Evening, everybody. My name's Richard Williamson, so I live at 1 Chapinge Close. I've lived there for 27 years now. My objection is on the grounds of highway safety and traffic issues, which is the reverse of the case you just heard before. In terms of there are lots of people that will be parking in and around premises rather than one supervisor. So my main objection details are Chaffinge Close is a very small and narrow cul-de-sac. There are 16 houses on there, very limited street parking. On-street parking causes access issues already. The nature of this business would require parking for key support workers, social workers, NHS staff such as counsellors, children's and adolescent mental health professionals, managers and the owners. This will cause safety issues at the junction of Chaffinge Close and Linnet Drive. This is an area where the children from the estate regularly congregate to play football, cricket, ride the bikes and all the stuff that we used to do as kids. It's the focal point of the estate. A reduced visibility caused by parking on this junction gives the danger of a serious accident. An example of this was the recent open day and a consultation by the company owning this facility. The event was attended by 4 members of their staff, none of whom chose to park on their frontage. All 4 were parked all over the entrance to Linnet Drive and Chaffinge Close. Basically obstructed the whole visibility. Turning in and out of the junction, you couldn't see a thing. There's kids there, bikes there. Just fearful for the safety of children on the estate. Parking at the junction on this occasion was both unsafe and illegal. In a nutshell, my objection is based on the danger of a serious accident caused by lack of highway safety. This is in turn caused by running a commercial business on a residential estate. Thank you.
Do members have any questions of the speaker? No? Thank you. Our other speaker, Daniel Owen. Applicant. Same procedure. If you like to change speaker on, then you've got 4 minutes. Thank you.
Good evening all. My name is Daniel Owen. I am the director and owner of Consistent Quality Support who's purchased the property. This isn't really anything to strengthen the application, but to give an opportunity for any concerns or any questions that may be asked. I'd like to thank Daniel for a thorough report and would like to open up for any questions that you may have concerns over the use of this property really.
Do members have any questions? Councillor Stevenson.
It's noted in the report that in regards to highways, it's not considered, or they wouldn't consider it a material change, as they would expect that it's sort of the people that probably might be similar to what it would be with normal use. I would put it that with potentially up to 4 carers plus potentially social workers and others that might be visiting, there would be a higher than expected number of cars at the property. Do you not feel that's the case?
In regards to social care visits, social care workers are only required to meet the children once a month, in which tends to be around 15 to 20 minutes. And that tends to happen between 9 till 5, which is normal working hours for the residents of that street. So I propose that it doesn't really affect the day-to-day running of residents there.
So Tempest Mitchell.
Thank you. Can you tell us pretty much the average age of the kids that would be in this home and what are the circumstances that may have led them to be there, please?
Our statement of purpose is between 7 and 17. Unfortunately, due to the number of children that are requiring these type of services, it'd be difficult to actually tell you the age of what would go in. I don't want this to turn into a sub story of why the home should be granted its permissions, but unfortunately these children have been taken away from home due to severe abuse such as sexual abuse, physical abuse, neglect, emotional abuse, kids that were never asked to be born and just want a first shot at life really.
So Tempest Mitchell.
Thanks for that. So I think what you're saying is troubled kids that need lots of love and lots of help. So does that not add to some people's concerns, residents' concerns, that services, the police, social services, health visitors, etc., will be there a lot, or potentially there a lot?
In all honesty, the team that is put together around these young people are extremely highly trained. We have team members that are trained in therapy. We use something called a PACE therapeutic intervention. So the team that will be supporting them are very, very well equipped in dealing with these young people. We are very, very proud of our reputation in regards to how we've helped some of the most challenging children turn their life around. And this could not be any different from a possible normal family moving into the home, to where you may have troubled teenagers with parents that might have not as much experience of what we do in regards to supporting these people to become valued members of the community. And we want our children to be able to go play with your children, have barbecues, and just live the life that they deserve to live.
Councillor Moxon.
Thank you, Chair. I think that the previous speaker mentioned this, but could you just give me a sort of a brief breakdown of what you've done in terms of speaking to local residents prior and during the application process?
Yeah, so Normally in this situation, due to the nature of what we do, we try not highlight that we are a children's home due to the vulnerabilities of the children. And we don't want that advertising to potential people that may cause harm or dysregulation to the children. But on this occasion, during the 7 objections, we thought it be necessary to meet the community, invite them into our home. We invited them to a barbecue, and we tried to give reassurance and guidance and information on which their worries were, and try and relieve that stress and anxiety. When people hear of a children's home, they think of naughty children, they think of children that are going to cause criminal damage and things like this. And we'd like to give the residents reassurance that this isn't what we opened homes for. And that was, I'd like to think, achieved when we had that meeting with the residents.
If I can just come back, I mean, other members of the committee will know that I'm often quite critical of companies that don't do that. So I think that's fabulous that you've done that. I just want to pick up on something that the previous speaker said, where he said that people that hadn't parked on the driveway. Do you accept that that might have been a sort of slightly problematic towards the application, that you're saying that people are going to park on the drive and then you didn't?
Yeah, I can acknowledge that, absolutely. The reason that I requested the team not to park on the drive was safety for the residents and not overcrowding, because I wasn't aware of the magnitude of people that actually came to the invitation. I will quite happily put my hands up to the fact that I may have made a mistake on requesting that, but it was in the safety of the residents that I requested not to be parked on the drive.
Any further questions? See any indications? Thank you.
Thank you.
Do members have any questions of the officers? Councillor Stevenson.
Thank you, Chair. Same question I put to the speaker in regards to highways and not being considered a material change and therefore not needing a full planning application. I would put it that for up to 4 social work, up to 4 carers rather on site plus potential other visitors would be surplus to what you would normally expect in a property like that. Is that not the feeling that you had as part of the application?
I think in many cases like this, it can be finely balanced in terms of numbers of cars, likely numbers of cars, numbers of staff. I think as a general rule of thumb, I think the expected median number of cars at the property would be 3, which is the sufficient, which is the driveway capacity. I think the 4 staff on the site at any one time, that's the high number. I think the anticipated median number would be 2 staff on site. I think social care visitors would be, well, as the applicant said, once a month. As far as thinking about highways, I think kind of the tricky thing with these is that the presumption the applicant puts forward when they apply for this is that it would be permitted development anyway and it wouldn't require planning permission. Thinking about, you can think of some fallback uses where you might say if it was a normal residential institution, it might need more than 3 spaces. I think, and if it was a normal fallback for a residential dwelling, it would only need 3. I think in any case, you could depends how you devise it really. If you think the quirk is in this case, we're considering it a C2 use because children can't form part of their own household. If this was adults in supported living, then the requirement for parking, if it's a planning application, would only be potentially 3. It might even be less than 3 spaces. It may be more. I think that the key thing we're trying to consider is there is a scenario where you could have 6 adults living in the house under a C3 use and they could all drive. In theory, a normal residential dwelling, if it was converted to a HMO into permitted development, may have, there could be 6 if you've got a couple living on their own at 95 each, like you may have no cars, but you could have a case where there are four cars or more on the property. So I think on balance, it was considered based on the materiality of that planning permission wouldn't be required.
Appreciate your insight on the thought process behind that. Thank you.
Councillor Tempest Mitchell.
Chair. I think this follows on from what Councillor Stevens just said, but I know that in the report they're actually the officers don't consider this to be an actual class 3 application. I'll read it, probably make more sense. Depending on the needs of the children, there could be a maximum of 4 support workers attending to provide the appropriate care required. It's therefore not considered to be a single household under class 3. Based upon the above, it is therefore accepted that proposed use does not fall into C3 category and therefore a change of use will take place. However, the question is whether it's material or not, which I think is what you just mentioned. But then if we look at North Devon, District Council versus Secretary of State, it goes through some criteria. Including the details of the proposed use and how this will operate on a day-to-day basis, including staff arrangements, numbers of staff, number and type of children and their particular circumstances, as we've had evidence to suggest that perhaps troubled children, I use those words really, really carefully. I'm a full-time teacher, so the degree in which the visitations from external agencies, interests such social workers, health workers, parents, family members, police, not there, but all of that is taken into that case, the North Devon case. Are we suggesting that those in these circumstances are not material?
I think when we looked at these before, we tried to explain that it is a matter of judgment when you're looking at these, and there isn't necessarily a right or a wrong answer, to be fair. So the point of highlighting the North Devon case is trying to explain that, as Dan's just explained. So when you get an application like this, children can't form a single household in case law, and therefore it changes to a C2 use. The question then is whether the change from the C3 use is materially, the change to the C2 use is materially different to the C3 use. And this is our thought process here, that a C3 use allows 6 individuals to live as a single household. So theoretically, as Dan said, you could have 6 individuals with 6 cars. So that's the higher end of the scale. So you go to the higher end of the scale for what's proposed here, which is 4 carers and 2 children. So is that materially different, the actual parking scenario, compared to if you did have the higher end of the scale of 6 individuals living as a single household as a C3? I can accept that people might view that very differently, and that's the nature of the beast, I'm afraid. But we have to make a decision, and in this circumstance, we don't think it's materially different as officers. But obviously members could think differently, and that's fine. So, but that's the thought process behind it as to where we've came. So these questions that are coming down here, that they're just some of the questions that you need to think about when you're looking at a change of when you're looking at a certificate application, because we don't consult anybody on certificate applications. So we haven't consulted the Highway Authority. It might be the case that you actually had a planning application for a change of use, and it falls foul of the Highway Design Guide, for example. But you've got to go back to that fallback of the C3 use and what could be accommodated in that C3 use, which is 6 individuals living as a household.
Members have any further questions of the officers? No indications. Thank you. I've got an apology to Councillor Garner. You're not on my list, so that's why you weren't invited to speak. The last one you were, but this one you weren't. So somehow there's been an administrative error. That's why you were overlooked. So we're now at the point of having proposer and seconder for the motion. I have a proposer for granting this certificate. Councillor Jackson, Councillor Hammersley. We're in debate mode. Anyone want to comment on the application? Councillor Moxham.
Yeah, just quickly reiterate what I said earlier. Often very critical of companies that don't try and interact with local residents. I personally think it's important to, and by the sounds of it, they've tried to do that. Whether it's actually sort of worked or not is a moot point, but by the sounds of it, they have actually sort of made an effort to try and speak with local residents and allay their fears. And I think it's been noted obviously by them that they're possibly a bit of a misstep not actually using the driveway facilities, but taking that on board, everyone makes mistakes, at least. So yeah, I'll be supporting this.
Any other comments? No. We move to the vote then, please. All those in favour of granting the certificate, please show. Any against? Any abstentions? Right, that application has been passed 7 for, 1 against. Right, Councillor Abbs back into the room. So planning application 2024-0133 CLPD. Application for lawful development certificate under the Town and Country Planning England Order 2015. Home for 2 children with support worker, no more than 6 residents where care will be provided, has been granted the certificate. When Mike gets back to his seat, I can move on to item 6 on the agenda, which is planning application reference 2024-0056 full 12 number supported living dwelling houses with the inclusion of staff and commercial space. Could I invite the officers to make the report, please? Page 27.
Thank you, Chair. Yeah, we've got quite a few updates on this to the report. The first one's from the Nottinghamshire County Council Planning Policy team, who confirm that they do not object to the proposal, despite the requested financial contributions not being secured due to the viability evidence that's been provided, which demonstrates that the scheme cannot support the cost of these financial contributions. Comments have also been received from Severn Trent Water, advising that foul and surface water disposal will be subject to a formal Section 106 sewer connection approval, with soakaways to be considered as the primary method of surface water disposal. I'll just draw members' attention to Section 6 of the Officer Report, which details that ground investigations have been undertaken by the applicants, which confirm that the site is not suitable for infiltration. So therefore, surface water is to be disposed of via a combination of surface water sewers, permeable paving and filter drains. Severn Trent have also recommended that an informative note is attached advising the applicant that the public sewers have statutory protection and may not be built over or close to or diverted over without the consent of Severn Trent Water. Finally, we've also received comments from the tree officer, but as set out in the report, there's no adverse impact on existing trees. So the fact we haven't had any comments from the tree officer doesn't count against the scheme. We've also had some very late comments from the Highway Authority, and I'll sort of explain these in detail because they're quite lengthy. But essentially, they've responded to the updated plans, speed surveys, and highway technical note which been provided, and they comment as follows. The visibility displays are shown as 23 metres to the north and 21 metres to the south. These visibility displays are based on speed survey data, which include 85 percentile speeds of 17.6 miles per hour northbound and 18.6 miles per hour southbound. The Highway Authority have examined the speed survey data from which these figures are derived, and the numbers of vehicles are significantly below that normally acceptable, and as such are not sound. They therefore consider it reasonable to base the speed survey data on, well, safe stopping distances on a 25 mile an hour speed in the absence of more robust data. The proposed visibility displays, according to the submitted drawing, are dependent on the removal of the existing retaining wall and regrading of the verge to 1 in 10, as well as removing and relocating the existing lamp column. It is unclear if regarding the required proposal will actually be achievable at this location, given the current embankment and limited space available. As no cross sections have been submitted, anything greater than 1 in 3 will require a boundary treatment. The car park has been amended to provide 7 spaces with turning. However, it has been provided at the absolute minimum distance, and therefore care would need to be taken to make sure any boundary treatment does not impact on the parking provisions. It is noted that condition number 14 in the committee report requires details of the provision of boundary treatments. Furthermore, it is not possible to simply resite a lamp column. A lighting design would be required, and as such, details of the relocation of the lighting column needs to be submitted for approval by the local authority. The amended technical notes is recorded as an approved document with the committee report. However, on review of the amended document, there are several inconsistencies where it is only partially amended to reflect the latest submission. Sorry, this is very lengthy, their comments. Right. So essentially, the Highway Authority do not consider the visibility display stated in condition 17 to be achievable, and they therefore recommend that this condition is amended and would suggest that a distance of 33 metres is conditioned, which is suitable for a 25 mile per hour speed. In consideration of the above, the Highway Authority do not view this application as complete. However, if the local authority are minded to approve the application, they don't object in terms of the general principles of the scheme, and would suggest that the following revised conditions are made. An amendment to condition 17 to require visibility displays of 33 metres in both directions. The applicant, by the way, has confirmed that this dimension would be achievable. They've also requested that condition 21 is amended to refer to the updated parking and turning area drawings, and additional conditions regarding the first 5.5 metres of the parking and turning area to be constructed in the bound surface, the parking area and boundary treatments to be provided before occupation of the units, together with no surface water to be discharged onto the highway. In addition, a separate condition is also required regarding the removal and relocation of the lighting column to be provided before the development commences. So essentially, we're looking at 2 revised conditions to that set out in the committee report. That's condition 17, where the visibility displays will be amended to 33 metres in both directions, and 21 to incorporate the revised plans. Turning to the actual scheme itself, the application is a vacant parcel of land occupying a slightly elevated position at the end of Princes Street, as you can see there on the plan. There's also an informal footpath which links through to Moore Street Recreation Ground to the rear of the site. The surrounding area is predominantly residential in character, consisting of a mix of 2 and 2.5 storey terraced and semi-detached properties and 3-storey flats in Victoria Court. The land immediately to the southwest of the site, as you can see there on the plan, previously contained 3-storey blocks of flats, similar to those in Victoria Court. However, these buildings, along with a community centre, which was on the park to the rear, and a garage block on the application site, were demolished in 2013. Planning permission has also recently been granted in 2020 for 6 semi-detached houses on the application site, although this consent has now lapsed. The current application seeks permission to provide 12 one-bedroom supported living units on the land. It would comprise of a single block which has been orientated so that it fronts onto Princes Street, providing an active frontage to the street scene. Parking would be located to the front of the proposed block. A pedestrian link would also be provided through the site from Princes Street to Moor Lane Park, providing a clear connection through the scheme. Proposed use of the building is for 12 single residential residents to live with their own self-contained flats, whilst also having a degree of support from staff members. The building will be staffed 24 hours a day, with staff levels likely to be 2 during all daytime hours and a waking or sleeping staff member at night. This, as such, sorry, just bear me a second. The application site would provide self-contained flats where residents live independently with a personalised support package delivered by approved care provider who are commissioned by the County Council. As such, the proposed assisted living units would represent a C3 use rather than a C2 residential institution. So essentially what's being proposed here are self-contained flats where each flat would have their own living room, bedroom and bathroom, and there would just be a small shared space. So essentially that's why it's a C3 use, because residents wouldn't be reliant on shared facilities. They'd have their own flats effectively. The site's situated on previously developed land within the Mansfield urban area, where policy S2 of the local plans seek to focus new housing development. As such, the principle of development on the site would be acceptable. The new building would be orientated so that it fronts onto Princes Street, therefore providing a focal point for public views in the street scene. The staggered alignment of the building, combined with its varied ridge line, would help reduce its overall bulk and massing and ensure the proposal respects the scale and proportions of adjacent developments. Its design detailing, including pitched roof and window headers, would also reflect the design features in the traditional terraced and semi-detached properties in Princes Street, further enhancing the appearance of the development. Therefore, it's considered that scale, form and layout of the development would complement its surroundings. In terms of highway impacts, conditions are recommended securing the appropriate visibility space and the relocation of the lighting column, addressing the highways concerns that have been received. Although the number of parking spaces is below the guidelines set out in the Highways Design Guide for C3 dwellings, given the nature of the proposed use where occupiers are unlikely to drive, the proposed level of parking is considered to be appropriate in this case. It's also suggested that a condition can be imposed restricting the occupation of flats to assisted living accommodation only, so the 7 spaces that are provided would provide sufficient space for residents. The proposal would also provide an acceptable living environment for neighbouring residents due to the separation distances involved with neighbouring developments. In terms of financial contributions, as this is a major application, there'll be several required contributions towards junction capacity improvements, bus stop infrastructure, open space and affordable housing. However, in this case, a viability report has been submitted that confirms that the scheme cannot stand the cost of these contributions. This has been independently assessed by an independent evaluator who agrees with the conclusion of the applicant's analysis. Therefore, we're not proposing any contributions in this case. Therefore, planning permission is recommended subject to the conditions set out in the report and the additional conditions that I have just specified.
Thank you for your report. I don't know if we've got Alan Forsyth here. No. No, so there are no speakers. Therefore, I'll ask committee members, have you got any questions of the officer? No indication. Oh, Councillor Bell. I mean, I've got him on the mind now.
So just one.
So am I.
Just one question. Car parking, you're saying that they're on the assumption there's many people there. Should it not be really? It should be spaces for each flat, just in case there is.
As was specified on the earlier application at Little Barn Lane, residents are unlikely to drive because of their specific needs. So again, it's going to be the residents are going to be people who've got limited. The learning difficulties are minor, so they can live in independent flats, but they just need that assistance from the care package to actually oversee things. So, but they won't actually drive. So the actual parking spaces will only be occupied by visitors and by the staff members on the site. So 7 spaces in this case is considered to be appropriate. And the actual parking standards are based on a standard C3 use. So in this case, if it was a general needs block of flats, they would need a greater degree of parking, but because of the special circumstances in this case and the type of residence, it's considered that the level of provision is acceptable.
Okay, thank you.
Any further questions? No. Would I have a proposer for the application? Councillor Stevenson, Councillor Tempest Mitchell. We're in debate mode. Does anyone want to comment? See no indication. No. Councillor Hammersley.
Yeah, as the local councillor for this area, I welcome this proposal because the land is currently in a derelict state and it's currently being used for fly tipping. So yeah, I support this proposal.
Yeah. Any other comment? No. Can we move to the vote? Can you just remind Councillor Bell that you can't vote because you left the room while the debate was going on? All those in favour, please show. Any against? Any abstentions? Thank you. That was unanimous. So item 6, plan application 2024-0056 full 12-member supported living dwelling houses with the inclusion of staff and communal space has been granted planning permission subject to conditions. Thank you. Swiftly on to agenda item 7, which is plan application reference 2024-0036 COU 50 Hazel Grove, Mansfield Woodhouse, temporary change of use from residential to residential doggy daycare business. I invite the officer to present the report, please.
Thank you, Chair. The application site is a semi-detached dwelling with an outbuilding to the rear and an enclosed back garden area in a residential neighborhood. The proposal is for a change of use of the property to provide a doggy daycare service on site, which utilizes the existing dwelling home, garden and outbuilding for doggy daycare for a maximum of 4 customer dogs, 2 to 3 days a week between Monday to Friday, from 8:30 a.m. in the morning to 6 p.m. in the evening. The application has been referred to the planning committee at the request of the vice chairman of the planning committee via the chair's meeting on the grounds of concerns about noise in the residential area. Public objections received have highlighted concerns over noise nuisance as a result of barking, trigger barking or behavior at the boundary fences between dogs living adjacent in multi-dog households. The size of the property to manage the noise from 6 dogs and the condition of the lawn, which is prone to flooding. Prior to the commencement of the presentation, there is one late item to report. The applicant has submitted further information in respect to objections that have been received. This information has been uploaded to the website, but for members' information, it is stated the following in summary. Dogs respond to neighbors' dogs in the garden barking at fence, and privacy screening has been put up at the fence. Barrier can also be added if required to keep them from the fence boundary. There are a number of policies and procedures in place which are viewed and agreed by licensing, which has also been addressed in the committee report. To assess, this includes dogs being assessed and provided a trial in the daycare to assess the behavior and suitability. Dogs will not be taken into the daycare if not suitable. Dogs will also be monitored at all times, so barking will be brought under control and stopped. In terms of the size of the property and the condition of the lawn, it is to note that the licensing team has approved the layout of the property. The applicant has also advised that she has removed stepping stones and filled holes where water gathers to mitigate the flood problem, and added a large gated area which is stoned for toileting and playtime if needed. Moreover, there is an additional work shed outside that has been insulated to control noise whilst dogs are playing or using it. This is a photo of the rear garden, and it shows the current boundary treatment. This is a photo of the work shed, which is on the right-hand side, and a gated area for playtime. This is the photo of what the inside of the work shed looks like, which is currently unfinished. And this is the photo of the rear of the house and the garden. It is to note that whilst licensing of the business falls under separate legislation to planning, the licensing team has confirmed that a license has been granted for 3 customer dogs, which excludes the applicant's own pets, for a period of 1 year. The main consideration for this proposal is the impact on residential amenity, particularly in respect of noise. The environmental health team is the main consultee in this regard and has been consulted. It raises no objections to the proposed change of use of the above property from residential to residential with dog daycare, providing the applicant successfully obtains a license from the council's licensing section to run such a business, and adheres by the conditions of the license. A condition restricting the opening hours of the business during Monday to Friday from 8:30 in the morning to 6 p.m. in the evening has also been recommended. The environmental health team has also stated that there shall be no more than 4 customer dogs in daycare on any day, and suggested that the applicant should ensure the noise from the dogs should be kept to a minimum so as not to cause a nuisance to neighboring properties. It is also important to note that the proposed business would not be full-time, and a condition has been recommended that the doggy daycare shall operate no more than 3 days a week. The applicant has also further advised that customer dogs would either stay for a full day or a half day, with pickup times no later than 5:30 in the evening or 1 p.m. in the afternoon, respectively. Moreover, it is considered that the number of customer dogs should be reduced to no more than 3 on site at any one time, in which a condition has been recommended. In terms of the layout of the property, the proposed floor plan shows that there would be sufficient space and rooms for play and isolation if required within the premises of the house. In terms of impact upon character and appearance of the area, there are no external alterations proposed, therefore the changes referred to above are not considered to be unacceptably harmful to the character and appearance of the area. In terms of highway safety, highways have not objected to the proposal on the grounds that the application does not have a detrimental effect on highway safety and capacity. The applicant has also stated that customers can park on the driveway for drop-off and pickups as the property is a one-car household with no other staff members. Drop-off and pickup times are also staggered every 10 to 15 minutes to mitigate noise and traffic. Therefore, it is considered that there would be no conflict with the aims and objectives of policy IN9 and IN10, which requires appropriate provision for vehicle parking. Overall, while it is acknowledged that the proposed development would result in a certain degree of noise, given the policy and measures outlined to manage the behaviors of the dogs in the daycare, the layout of the property and the site, the proposed operation hours, and that this would be a temporary change of use for a 12-month period for 3 customer dogs on site at any one time, it is not considered that a refusal for temporary permission would be justified. The granting of a temporary 12-month planning permission would allow for the operation of this business in this location to be assessed further to ensure it is complementary to this residential area.
Do members have any questions of the officer? Councillor Abbs?
Thank you for your reports, been very nicely done. The question got, how do you know to keep to the 3 dogs? Are they committed in some ways? Because I do know ultimately where we've granted somebody else permission to do this and they've abused that system. Is there any way that we can actually keep an eye on to make sure they are following their actual regulations of 3 dogs?
Sorry.
That's the button.
Yeah, sorry about that. So just the general point on planning conditions. It's kind of the general principle of planning conditions is that obviously we receive as an authority, we receive several hundred applications per year. During this application, I think there were 2 objections were raised by residents. So I think it's the general principle of planning conditions is that there's kind of it's kind of they're placing good faith that the applicant would adhere to them. We have obviously where we receive complaints from a local resident, the planning enforcement officer, we have a legal duties and authority to investigate any breaches of planning control. So I think that's as I say, a general principle of we can't monitor every single planning condition on every permission, just due to sheer volume of applications received. But that's not unique to sort of this application. That's kind of a principle that's kind of addressed sort of for every planning application. Environmental health also and licensing also have their sort of own separate regimes to control this. I think the good thing about this application is it is a temporary permission. So were a committee to resolve the grant permission, it would be issued effectively would only be kind of until September 2025. So if complaints were received after that, we could effectively take enforcement action on the grounds of an unauthorized or an unauthorized sort of development because of the nature of the time restriction. So in that sense, we would enforce the condition in the same way that we would enforce any other planning application, large or small, really.
Thank you for that. Appreciate what you're saying. Just was concerned because I know we've had a few complaints come up at a certain place where they're doing care centre, but cleaning dog, and they've increased. Not actually said anything. Don't seem to be doing it either. I know is except that case of keeping an eye on things where can get out of that. I mean, I've got 2 dogs and the noises out the little sods. To be fair with you, you can't stop dogs barking no matter what you do, unless you treat them every 5 minutes. But just be concerned that to ensure they keep that number. So I was mentioning.
Yeah, I think.
And I know what you're going to say.
No, I think it's a really difficult one. You know, as Dan says, conditions are put on in good faith that they are kept. And then I suppose it's due to staffing and resources. We can't monitor every single planning condition that's put on a planning application. It would be nigh on impossible, really. So it's the same as any planning condition that goes on. We are reliant on members of the public to report in breaches. But I think here you have got a little bit more control because you've got the licensing side of things. And whilst we're not here to discuss licensing today, it's just about planning matters. But this business has to have a license, and therefore licensing will also be actually monitoring. And I understand because I spoke to them that they monitor every 6 months, I think it is. So there is that little bit more certainty compared to an application that doesn't need a license. I take your point. It's difficult.
Very much. Are there any other questions of officers? Councillor Tempest Mitchell.
Thank you for the report. I thought that was excellent. Thank you. Just one thing about can we have that picture of the shed on the screen? Is it on the outside? Is it metal or is it a brick building? And my worry is that any noise in that building as it looks there probably make no difference if they're indoors or outdoors, would it be metal?
I've been advised by the applicant that it is currently unfinished. So the picture that you're looking at, the photo that I've provided, what it looks like inside, it's currently unfinished. So I believe the applicant would have works to be further furnish the work shed to provide more insulation to prevent the noise.
And just one more really about the temporary application in a way that they've got a license for 3 dogs, applied for 4 dogs. We're always told that we can only work with what we've got, and I get the condition part, but surely we would be, and this is probably really technical, turning it down because they've applied for 4, because actually we're amending their application. Secondly, on the same thing, that if we get complaints from neighbours, do planning, enforcement and licensing liaise so that we could recommend not only withdrawing the consent if it was given, but also therefore the licence?
Sorry, thank you, Councillor. So it's been a bit of, this application has been with us for some time. So I think the description of development doesn't specify the number of dogs. That's controlled by condition. So the original planning application, I believe, was for 6 dogs. So so the officer report it almost goes for a bit of an evolution, really. So the description, it mentions 4 dogs. But I think in the assessment it talks about 3, and that's controlled by condition. So the legal constraint in that regard would be the decision notice. The officer report is kind of like an assessment document, but the legal controls that we would place on from the perspective of planning would be from the decision notice. So the permission is for 3 dogs, and that stems from the condition. As far as I don't think we can, I don't know about revoking a planning permission. That would require the height. Once we've granted a permission, we can't. To revoke. It's next to impossible. But I mean, the revocation really is the time constraint that we've given them. So, or any enforcement action we could take to enforce against the breach of that planning control. I don't know about licensing. I guess I don't know what constraints they have, but I don't know. Claire, if you want to maybe come in to cover anything I've missed.
Okay, so in terms of the liaison between licensing and planning, obviously we're literally just around the corner from each other, so we do have dialogue, and whilst licensing isn't a planning consideration. It doesn't make sense not to have some joined up thinking on it really, to grant one without the other. So if we can get some compromise, then we will look to do so. And that's what's happened in this planning application. So whilst they applied for 6 dogs, it's always in the gift of the case officer to try and get a compromise if possible. So for example, you could have an extension that was 6 meters and that was too long. So you might say, oh, well, no, you can have 4 meters. So there is that negotiation period that if you think you can get an acceptable scheme out of it, then the planning officer normally will negotiate. So it's not just a cut off you apply. We don't tend to operate like that because we try and work proactively with the applicants. And that's what's happened in this circumstance. So it's been a little bit of a mixture between liaison with licensing, liaison with the applicant, and we've come to the conclusion that whilst we have some concerns about the noise, I think that's fair to say, because I don't think it would be reasonable to say that we don't. The happy compromise was to reduce it from 6 down to 3 customer dogs, and give the temporary permission for 12 months, which gives the local planning authority time and gives it another bite at the cherry, so to speak, because they'll have to apply again if they want to keep it permanently. So at that point in time, if there's been complaints or environmental health complaints in that 12-month period, when that comes back to committee or whichever delegation process it goes, that would obviously be a material consideration in any decision at that point in time.
Are there any more questions of the officers? None? Must admit it is confusing reading the report of the number of dogs on site. Got 2 themselves, it was 4, then it was 3, and 2's mentioned. It's yeah, confusing. I do believe it's for 3 customer dogs, 2 to 3 times a week between them hours. 1 year. Do I have a proposer for this application? Councillor Abbs, Councillor Bell. Do you want any comments? Don't appear to have any. Oh, Councillor Abbs.
Thank you. I'd like to say that you know certain issues. Councils on this. We are investigating the issue to the care about how people do and the enforcement officer being able to find things out. The photo there, some of the guys that looks like it's been insulated as well. It's like corrugated. The outside is certainly not in.
Okay. We have a show of hands. All those in favour, please show. All those against? That motion's carried. 7-4-2 against. Thank you. Yep. So thank you for that committee. Planning application 2024-0036 COU 50 Hazel Grove, Mansfield Woodhouse, temporary change of use from residential to residential doggy daycare business has been granted a 12-month permission with conditions. Thank you. We're approaching 8:20. I need a proposer and seconder to carry on till 9 o'clock, if that's possible, when we will be kicked out of the building. So can I have a proposer to extend? Councillor Hammersley, Councillor Bell. All those in favour? Any against? You carried. We've got an extension till 9 o'clock if necessary. Hopefully we can get through the remaining business a little bit quicker, although one is a major application. On to agenda item 8 then, which is application reference 2024-0167 COU, 57 Leighton Avenue, Mansfield. Change of use from a 3-bed residential dwelling, use class C3, to an 8-bed house in multiple occupation, use class sui generis. I invite the officer to make a report, please.
Thank you, Chair. The application has been referred to the planning committee due to the number of objections received. The applicant is seeking planning permission to change the use of number 57 Leighton Avenue from a residential property into an 8-bedroom house in multiple occupation HMO, which would fall under use class sui generis. It should be noted that the applicant has accepted a planning condition to restrict the number of occupiers to 8 during the course of the application, and the application has been assessed on this basis. Number 57 is a semi-detached residential property with a detached garage to the rear of the site. Proposed external alterations include a new door to the side elevation, the replacement of 2 existing openings, and blocking up of 2 existing openings, all at ground floor level. Objections has been received in relation to the numbers of HMO in the area, amenities of future occupiers of the development, as well as amenities of the existing occupiers around the proposed development. Policy H7 supports development proposal relating to HMO subject to criteria including impact on character of the site, mix and balance of the communities, and adequate provision of internal and external amenity spaces. Proposal would have no impact on the characteristics of the site as there are no external alterations proposed in elevation, and it will remain in residential use as a 2-story property. It is acknowledged that there are other HMO properties within the locality. However, policy X7 does not specify or limit a maximum portion of properties that can be in HMO use. The application site is located in close proximity to the town centre, which is considered to be an appropriate location for this type of residence. Turning to the amenities of the future occupiers of the development, an HMO is normally subject to a requirement of a license, which is assessed against the DASH Landlord's Guide. This is a separate regime from the planning system. From a planning perspective, all proposed bedrooms would meet the technical requirements set out in the nationally described space standard in terms of bedroom floor area. The application site features a private rear garden, and all proposed habitable rooms would also be served by a list on opening. It is therefore considered that the proposal would be in accordance with the criteria set out in policy H7. Turning to the impacts on amenities of the existing occupiers around the proposed development, it is considered that there would not be any loss of privacy concerns, overbearing or overshadowing impacts to any of the neighboring properties given the nature and location of the proposed external alterations. It is considered that the proposal to enable the property to be occupied by up to 8 occupiers would not generate an unacceptable level of noise that would significantly harm the amenities of existing residents. The environmental health team has also been consulted and raised no objections in principle subject to conditions. Objections have also been received in relation to highway safety. The latest comments from the Highway Authority raised no objections to the proposal subject to conditions. It is acknowledged that the proposal would result in shortfall in on-site parking provision as per the Nottinghamshire Highway Design Guide. However, the application site is located within walking distance to the Mansfield Town Centre, which is considered to be the most suitable and sustainable location for this type of development. A residence parking scheme is also operated on Leighton Avenue. Bike shed and storage facilities for 8 bikes will be provided, and the existing detached garage would also be retained as a parking space. Besides, under the current permitted development rights, a building under the use falling within use class C3 dwelling houses can be changed into use falling within class C4 houses in multiple occupation, which allows the building to be occupied by between 3 and 6 unrelated individuals, without the need of planning permission subject to conditions. This forms the fallback position of this proposal. As such, it is considered that the shortfall of parking provisions is acceptable, and a refusal in this regard would not be justifiable in this instance. Objection comments have also been received raising concerns in relation to the security of the site and the locality, the number of beams needed, building works are started and completed for the past year, mitigation of impacts on biodiversity and the drainage system. They have all been assessed and are considered to be acceptable and appropriate. This photo right here shows the interior of the existing detached garage, which has been conditioned to be retained and to be used by future occupiers for parking of a motor vehicle only. This photo shows the access road to the rear of the site connecting to the existing detached garage. Final photo right here shows the rear garden of the site. Conclude. It is considered that the principle of the proposed change of use of the existing residential property into an 8-bedroom house of multiple occupation, which would fall under use class sui generis, is acceptable, and that it would not have adverse impacts in terms of the visual amenity of the dwelling as well as the amenity of the neighbors. Given the location of the sites, provisions of cycle storage facilities, and the permitted development rights, on balance, it is considered that the proposal would not result in unacceptable impacts on highway safety. Recommendation is therefore to grant planning permission subject to conditions which limits the occupiers to 8 provision of cycle storage facilities prior to the occupation of the development, hours of construction and delivery of materials, as well as to retain the existing garage for parking purpose solely. Thank you.
Thank you. Well, do members have any questions of the officers? Councillor Moxham.
Just trying to find it on here. Can you just clarify how many parking spaces are going to be at this? A little bit confused.
Yeah, so there'll be 1 parking spaces provided on site, and this will be provided via the existing detached garage to the rear of the site.
Say.
Yes, that's correct. 1 off-site parking provision.
So, it says in the report that although we've not adopted the standard, the design guide requires 1 space per bedroom. So and plus 1 visitor space per 3 bedrooms. So it requires 10 parking spaces. We've only got 1.
Yes, in terms of the highway design guide, I think that's correct. But one thing to consider within this proposal is that a building within the use class C3 can be changed into use class C4, which would allow up to 6 unrelated individuals to be occupied without the need of planning permission, subject to conditions. And obviously the application site is located within a fairly central location, is in close proximity to the Mansfield Town Centre, which offers shops and bus station as well as the train station. So on balance, it is considered that the shortfall in parking provision in this instance is acceptable.
Yes. Yeah, so we've had a discussion with the Highway Authority about this because originally they objected to the proposal because their highway design guide it doesn't take into account there's a fallback position. So it comes out quite it's unrealistic, to be honest, to have 10 or 12 car parking spaces for a HMO for 8 people. So you have to look at the fallback, as Howard said. So you can have the property at the minute is in C3 use, which is a general C3 use, and that can change to a 6-bedroomed HIMO without the need for planning permission. So in effect, that would have exactly the same amount of car parking it's got, and we would have no control over that. So the question is, does the introduction of a further 2 people tip the balance in terms of parking or refusing an application? And there's other material considerations to consider in this application. So the main one being is that it's in a sustainable location, and it's got cycle parking is going to be provided, and people can walk into town. I think furthermore, there's a further control there as well on this street because there's a residence parking scheme. So if somebody moves into that HIMO, they would have to then apply to Notts County Council to get a residence parking permit, which would obviously then be controlled by the county council. So I think in this circumstance, it would be very difficult to refuse the application on parking grounds when the fallback position is one that 6 people could move in there without the need for planning permission.
Do we have any further questions? Councillor Hammersley.
Chair. Dan, could you just put the photograph of the detached garage on, please? Screen. Yeah, that's the one. Yeah, is there a side view as well, please? It looks a very, very old garage. You can't see anyone to park the car within there, to be honest.
That condition has come as a request of the Highway Authority, and to be perfectly honest with you, I don't know why why they want that to be retained, because even if it was going to be demolished, I don't think we would be recommending anything different to what we've recommended.
Yeah,
The only thing I can think of, and I don't even know this, but is if it turns back into a residential property again, that they maybe want to have safeguard what was there originally. That's the only thing I can think of, but I don't know that for a fact. I don't know the
It looks a
rationale.
real
behind it.
eyesore, and it's got a asbestos roof. Yeah, okay.
Councillor Tempest Mitchell.
Thank you. Is the fact, my concern with it is that it's a 3-bedroom house or 3 or 4 bedroom house on a street of 3 or 4 bedroom houses, and all of a sudden we're going to plonk 8 different people, unrelated people, into that house. Is that not a concern?
So there have been similar proposals that have been approved within the locality. So it is not dissimilar from what has existed or what is currently existing in the locality.
We're always told that we deal with the one that we've got in front of us, so I'm only going to talk about this one. It seems to me that 8 people living in that house has the potential of being chaos. It might be perfect and everybody might live in harmony. But 8 people sharing what is at the moment a 3-bedroom house, unrelated people, seems to me that that has the potential to be an absolute nightmare for the residents. I just don't see that there's any or no consideration of that.
Bedroom house at the minute, and obviously the HIMO will actually have shared facilities, and they will convert some, maybe it's a lounge into a bedroom or whatever it is. I mean, that's the reason why planning permission is required, so there's some control over them. Comes back to the debate we've had all night, really, in terms of we're looking at planning, but also, as Howard said, these do also require another license as well, which controls I suppose the nitty gritty of what a HIMO is, in terms of standards and spaces and fire escapes and all those sorts of things. I mean, in terms of planning, we're really looking at the impacts that will arise from putting 8 people. And I will say as opposed to 6, because they could do that without the need for planning permission in that property, and whether the extra 2 people are actually going to warrant a refusal of permission and create harm to the locality in terms of the issues that have been raised in the report, such as parking or amenity. And the officer opinion is no, it wouldn't, and we've got no highway objection either.
Any other questions? See none. Could I have a proposer for the application? So Stevenson, seconder. Councillor Bell. Any comments? Councillor Stevenson.
Just in regards to the parking situation, really, I found myself in living in a building that almost looks identical to that. Actually, it's uncanny. For a length of time before I moved here, and it was one of 6 in total. There's only one who drove, so I would say it is reasonable for a property like that to find you wouldn't all have cars. However, what I will say is in the street there was a number of other similar properties. And he did drive. If you didn't get back within, 10 minutes of rush hour start, and you did find that it was a struggle to get a space. Certainly not one outside your property. So, you know, I do take on what you're saying in regards to the car situation, but I would say from my experience, it would be a struggle for spaces on there. So just a comment on that, really.
Councillor Answer.
Chairman, it is a predominant area where there are a lot of HMOs in that area. So, you know, it's just another one. But I just hope that he maintains his properties, but he maintains his garage and his garden.
Yeah, I think the garage is not great. I must admit, personally, I don't like to see these applications for HMOs, but I can see the reasoning behind looking to get a permission on this one, because it's 8 and they can have 6 without planning application. Therefore, there'd be no control at all. So I think I'm just about in favour of it. Thank you for your comments. Any further comments? Councillor Bell.
The answer said this is not just the first stage of that area. It has always been, as my colleague said, first up, best dressed. Get back early enough, get a parking space. That's always been the case before HMOs came. Yeah.
Any further comments? Can I move to a vote then, please? Those in favour, please show. All those against? Abstentions? Thank you. That's carried 5-4, 2 against, 2 abstentions. Thank you. So plan application 2024-0167 COU, 57 Leighton Avenue. Change of use from a 3-bedroom residential dwelling, use class C3 to an 8-bed house in multiple occupation, use class sui generis, has been granted planning permission with conditions. Move on to agenda item 9. Which is a fairly major application. Hopefully it'll be a simple one to assess. Yeah. Right. We'll call you back in if we get through it. So planning application 2024-0301 full. It's the Mansfield Community Hospital, Stockwell Gate, new community diagnostic facility for the NHS. Could I invite the officer to make a report, please?
Chair, I'll try and rattle through this really quickly. Right, in terms of updates, we've had updates from the Environment Agency confirming that based on the recent site investigation report, the first part of the proposed condition 25 has been satisfied. However, the remediation strategy and verification plan elements are still required to be completed. As such, the first part of condition 25 should be amended as follows. No development approved by this planning permission shall commence until a remediation strategy to deal with the risks associated with the contamination of the site have been submitted to and approved in writing by the local authority. This strategy shall include an options appraisal and remediation strategy, giving full details of the remediation measures required and how they are to be undertaken based on the results of the submitted site investigation report. The remaining parts of condition 25, 26 and 27, as requested by the Environment Agency, remain as drafted in the report. And if I can briefly go through the proposal, members may remember that an application for a community diagnostics facility came before the committee earlier this year. and was approved, subject to section 106. That section 106 was signed and the planning permission has been granted. What's happened is that the NHS haven't got the funding to implement that larger scheme. So this is proposing a much smaller scheme. So it's only single story in size compared to the 3-story building which has previously been approved. And then what they've also done is, if you can see on the slide there, the building on the right hand side is an existing structure. So what they're going to do is refurb that element to provide the extra space. So essentially what we've got is a single story building which reflects the design, materials and appearance of the other buildings on the hospital site. So it's considered that it would be well related to its context, and also the impact on the new residential development which is situated to the rear would be less than that previously approved, because the scale and bulk of the facility would be much smaller. In terms of contributions, the contributions that are required relate to bus stop infrastructure, which was part of the previous consent, although due to inflation, the increase in costs of that has increased by just over £2,000. So there's a revised contribution of 18,400 now required. The proposal also includes proposals to secure 10% of biodiversity net gain on site, and this will also be secured via a section 106 agreement. So in summary, it's considered that this scheme is reduced in scale compared to the previous permission, and therefore the impact on the character and appearance of the area, neighbouring residents, is less. So planning permission is recommended, subject to a section 106 agreement, securing the necessary bus stop infrastructure works, a travel plan monitoring fee, and the monitoring of the biodiversity net gain.
Thank you for that sharp report. Do members have any questions of the officer? See any indications? Can I have a proposer for this? Councillor Answer, Councillor Stevenson. Do you want to make any comment? To see that we're getting a development in a smaller scale. I'll move to the vote. All those in favour, please show. Any against? Any abstentions? That's unanimous. Thank you. So planning application 2024-0301 full. The new community diagnostic facility for the NHS has been granted planning permission, subject to the completion of a 106 legal agreement for the bus service contribution, the BNG and the travel plan monitoring fee. Thank you. Can you invite Councillor Jackson back in? Quickly. Item 10 is the appendix for human rights. Can we have a show of hands that these be noted? It's unanimous. And item 11 is the planning appeals decisions, and there were no appeal decisions received during the above period. So with that, I will close the meeting and thank you for your attendance and wish you a safe journey home.